3, 2, 1, start. Public interest litigation itself says that this is a litigation for any public interest. In the words of some learned people, we can say that public interest litigation is a litigation which can be filed in any court of law by any public spirited person for the protection of public interest. Now, a question comes in the mind that what is public interest? So, the answer is any act for the benefit of the public is in the public interest. And those acts are such as pollution, terrorism, road safety, constructional hazards, etc. In all these activities, we can clearly see the public interest. As it is said that this petition can file any public spirited person, so it means that there should not be the interest of only himself. There in world only says that it can be possible that in that act for what he is filing a PIL, therein a small part of his benefit also hide, but it is not mean that he cannot file. If this is interest of public, then he can file public interest litigation. Public interest litigation is not defined in any statute or any act. It has been interpreted by judge to consider the intent of the public at large. This is just like a writ petition which is filed in High Court or Supreme Court under Article 226 for High Court and Article 32 for Supreme Court. When public interest in affecting at large, then this can be filed, but affection on only one person is not a ground for filing this petition. There are some various areas where a public interest litigation can be filed. Violation of basic human rights of the poor, content or conduct of government policy, compel municipal authorities to perform a public duty, violation of religious rights or other basic fundamental rights. These are the main areas where any public interest litigation can be filed against state, central government, municipal authorities, and not any private party. However, private parties can be included in this as a respondent after making concern state authority. This petition is filed in High Court or Supreme Court just the same manner as other writ petitions filed. There is some fee for this purpose, and its hearing proceeds is also just like other cases. In early 90s, a judge had treated a complaining postcard as public interest litigation, so we can say that a letter also may be treated as writ of public interest litigation. Some other cases are also there which we will discuss in this project. In India, the first case of PIL was filed in 1976 named Mazdoor Kamgar Sabha versus Abdul Bhai, where Krishna Iyer allowed a group of people to file petition on behalf of others. The rights of the member were violated. Krishna Iyer held either one individual or group of individuals together can come to the court. But sometimes misuse of this petition also comes into picture. This is the problem in PIL, that many times this misused by some people. Stop.